Good afternoon, Father Principal.
Yeah, good afternoon, sir.
Good afternoon.
Your Lordship.
Good afternoon. Good afternoon.
Welcome.
Good afternoon. Thank you so much.
Good afternoon, Your Lordships. This is Dr. Irfan, Assistant Professor at CAIL, Academy Institute of Law. At the outset, I may be allowed to express our indebtedness we owe to Your Lordships for accepting our invitation to adjudicate the first National Moot Court Competition 2021. We welcome you, Your Lordships. Before we start with our session and we would like to confirm that Your Lordships do have a copy of mark sheet, moot proposition,
Yes.
memorials from both the teams. Your Lordships, do you have all of them, or would you like us to resend them?
No, it's all right. It's all right. Yes.
So your Lordships, would like to just brief about the session, how it will go. It will be a 50-minute session. Each team will have 50 minutes to argue its case. Speaker one will have at least a maximum of 35 minutes to speak as a time break, maximum of 35 minutes, and the rest can be used by speaker two. Also, Your Lordships, you can allocate them 10 minutes for rebuttal or sub-rebuttal, if Your Lordships please.
Yes.
Your Lordship, any clarification you may ask so that we may.
No problem. No problem. Nothing. Don't worry.
Thank you very much.
Let us see how as it goes.
Yeah.
Irfan, sir, Justice Kumar.
Oh, it's 2-5. Justice Kumar is not joined yet.
Okay.
He's just facing a little bit of difficulty joining.
Technical.
Yes. He'll just join.
Your Lordships, Justice N. Kumar is joining in 1 minute.
Yes.
Usually in all governing council, Justice Kumar will be before time. Maybe half an hour, maybe 45 minutes.
Oh, yes.
Today because of the technical issue. maybe.
Technical problem. Technical
yes.
problem.
Probably by this time, he also must have been used to this virtual proceedings.
Yeah, yes.
He has come.
Your Lordship, Justice Kumar. Hearty welcome, sir. Hearty welcome.
Namaskara, sir.
ನಮಸ್ಕಾರ.
Namaskara.
ಚೆನ್ನಾಗಿದ್ದೀರಾ ಸರ್? ಚೆನ್ನಾಗಿದ್ದೀರಾ ಸರ್?
Sorry, there was some internet hitch.
No problem, sir. ಚೆನ್ನಾಗಿದ್ದೀರಾ ಸರ್?
Fine,
Technical hitch.
No, I was telling your Lordship that usually Justice Kumar will be before time, maybe half an hour, 15 minutes for the governing council.
Yes.
This of the technical issue. No issue, sir.
And before we begin, we will wish Justice Kumar a very happy birthday. Tomorrow is his birthday. Many happy returns.
Advanced happy birthday, sir. Birthday wishes.
Thank you. Thank you.
Your Lordship, Justice Kumar, would you like us to brief about the MOOT again?
Don't do
The
it.
timings.
Please go ahead.
Thank you.
I have been a part of this mood for the last 20 years.
Thank you, Your Lordship. Yeah, participants, please switch on your cameras. We request you to please give your time briefing and to the court clerk so that it may be noted down. Let petitioner begin with its case.
Which is this team? Just to be sure, so that when we mark, we know which team. Team number.
So the petitioners are team number 30.
30. Okay.
Greetings to the honorable bench. The council solicits the permission to begin.
Yes, please.
Please begin.
Much obliged. The council seeks the permission to address the bench individually as your lordship and collectively as your lordships.
Yes, yes.
Fine.
Much obliged, your lordships. The council is appearing in the matter of Education Rights for You NGO versus the Union of Hodu, clubbed with the matter of Dr. Om Press versus the Union of Hodu. The council, along with my co-counsel 30S2, is representing the petitioners in the present case. Your lordships, the petitioners have approached the Honorable Supreme Court of India in the present case under the jurisdiction of Article 32 of the Constitution of Hodu, which is also being argued. The maintainability of the plea is also being argued by the petitioners as the first issue of our contentions. Your lordship, this council will be taking a total time of 27 minutes, while my co-counsel will be taking a total time of 23 minutes. Your Lordship, the Council now would like to ask if your Lordships would appreciate a brief perusal of the facts of the case.
Yes.
Yes.
It's up to you to argue how you would like to go about it. Please go ahead.
Much obliged, your Lordships. So, your Lordships, the present case stems from basically the roots of the contention begin from the starting of the pandemic in January 2020, when the World Health Organization declared it to be a public health emergency of international concern. Pursuant to that, there were many restrictions which are imposed on movement in the form of lockdowns, and thereby education institutions were also shut in the state of Hodu. Your Lordship, the government then enacted an online learning ordinance in April 2020, which provided for all education institutions to compulsorily switch to online learning, and made them liable to provide e-learning resources to the students without the ordinance making any provision of how it is going to be implemented and how the students will get that access to online learning. Your Lordship, thereby there was a report of the committee which stated that there has been a tremendous loss of learning during this pandemic, and pursuant to that, these two writ petitions have been filed. First one by an NGO. The first writ petition, claims that the state, that the ordinance which has been promulgated does not benefit the children in the country, since the students have not been provided with the technology to access the digital resources. In addition, it demands that the state be made tortiously liable for providing these free digital accessories, and also that the present policies of the state are not in conformity with the international obligations and the international conventions. Your Lordships, the second petitioner, Dr. Omprez, is a philanthropist and an educationist who is also a renowned personality, as he was awarded the Hodu Ratna, the highest civilian award, for his contribution in the field of education. He has claimed that this education is something which is not very healthy for a child's overall development during the childhood, and thereby the ordinance which makes it compulsory to continue with online education is unconstitutional. Your Lordship, the Council has briefly stated the facts of the case and now seeks a...
If I may ask you a preliminary question, when you say this is not the best of education, are you not mixing up constitutionality with wisdom, desirability? What is best is a different thing. What is constitutional or unconstitutional is another thing. Kindly keep that in mind when you address.
Indeed, Your Lordship, that is very right. And the Council the Council will be contending in the case based on the merits and the violation of fundamental rights, and not just on wisdom and the best practices. Your Lordship, the Council would now seek the permission to lay down the issues in the present case.
Yes.
Please.
Much obliged, Your Lordship. If Your Lordships would refer to page number 12 of the arguments advanced, page number 12 in Roman numerals of the arguments advanced of the memorandum of petitioners, 4 issues have been raised by the petitioners. First one, whether the present writ petitions are maintainable in the Honorable Supreme Court. And second one, whether the 2020 online learning ordinance is constitutional. These first 2 issues are being dealt by this Council. The third issue, which is whether the state is tortiously liable to provide free digital accessories, and the fourth issue, that whether the state's policies are not conforming to international conventions. The third and the fourth issue will be dealt by my co-counsel.
Do you have a doubt about the maintainability? You're the petitioner, you have come under Article 32. Do you doubt about the maintainability that you want to address arguments on that?
No, Your Lordship, that issue has been raised only to address any concerns if the Honorable Bench might have.
No, if the respondents have.
Yes, Your Lordship. If the
then I think you can spend more time for that in reply. I mean, this is what I would suggest. Please go ahead in your own way.
Much obliged for that suggestion, Your Lordship. The Council would the Council would thereby say that the Council seeks the permission to move directly to the second issue, and simply by stating that we have approached with a bona fide intent under Article 32 of the Constitution, and we are claiming a violation of fundamental rights. And even in the present case, the petitioners, an NGO which works for students, and Dr. Omprez, who is an educationist, represent the interests of the students in this litigation.
What is the fundamental right which is in suit?
Your Lordship, we are arguing that fundamental rights under Article 21, that is right to life, 21A, that is right to education, 14, right to equality, and 19, right to freedom. These 4 have been violated, which the council will be proving in the present context.
Under 19, what are you trying to emphasize? 19.
Your Lordships, we have first basically emphasized on 19(1)(g) that it is restricting the right of educational institutions to carry on their occupation. However,
No. Are you appearing for educational institutions or are you appearing for the students?
Indeed, Your Lordship, we are appearing
I think we can't mix up the two.
Indeed, Your Lordship, we are appearing for the students. The council would just like to clarify to Your Lordships that this argument is being contended from the students' perspective. Because if education institutions, their right to occupation is infringed, it will anyways affect the right to education of students who are studying in those education institutions on a large scale under the ordinance.
Appears to be very far-fetched. Anyway, it doesn't matter. Yeah.
So, could Your Lordships grant the council the kind permission to begin with the second issue?
Yes.
Much obliged, Your Lordships. Your Lordships, at the outset, the council contends that the unconstitutionality of this ordinance is being contended that on the basis that it violates the fundamental rights under Part 3 of the Constitution of India. When read with Article 13, Article 32 empowers the Honorable Supreme Court to review such legislations or laws which violate such rights. Before beginning with my four-pronged argument regarding the violation of fundamental right, the council would request the honorable bench to kindly pay attention, to kindly note the assertion in paragraph number 8 on page number 2 of the arguments.
All right, please read.
Your Lordship, in paragraph number 8, pardon me, Your Lordship.
We will read. You argue.
Yes.
Make us read your papers. You argue. We are here to hear your argument.
Yes, Your Lordship. The council will keep that in mind. So, Your Lordship, the council argues that it is whenever we contend the constitutionality of a law, we need not necessarily look at the subject matter. It should also be the effect of the ordinance, which should not violate any of the fundamental rights. The council is contending this under the authority of Bennett, Coleman and Company versus the Union of India, a case of 1972, in which it was clearly held that the effect of a law must be kept in mind while adjudicating its constitutionality. So, Your Lordship, we hereby state that the effects of the ordinance are such that they are violating the following rights which we are contending. With Your Lordship's permission, the council would now begin his four-pronged argument, firstly starting with Article 21 and 21A in particular. Your Lordship, Article 21A states of the Constitution of Hodu, I would like to bring your kind attention that it is a little different from the Article 21A of the Constitution of India. If Your Lordships would, in paragraph number 22 of the MOOT proposition, it lays down, Article 21 says that the state shall provide free and compulsory education to all children. Your Lordship, Article 21A of the Constitution of India talks about children between the age of 6 and 14. Article 21A of the Constitution of Hodu talks about all children. That is a point which the council wanted to bring to the notice of the Honorable Court.
What is the population of your country?
Your Lordship, we are not provided with that exact figure in the MOOT proposition. However, in clarification number 18, it was conveyed to us that all statistics of the Union of Hodu are also in parimateria to the statistics of the Union of India. Thereby, we contend that it is similar to that of India, that is around 1.4 billion. If with Your Lordship's kind permission, the council would wish to argue further.
Yes, please.
Much obliged, Your Lordship. So, Your Lordship, after this point, the council would like to argue that under Article 21A, which is the right to education, the Supreme Court has held, Honorable Supreme Court has held in various judgments that right to education also includes the basic infrastructure which is required for this right to be realized in the actual scenario. Thereby, Your Lordship, the council contends that in absence of such infrastructure, right to education will lose its entire meaning. Your Lordship, the council would like to draw the Honorable Bench's attention to paragraph number 12 of moot proposition of the arguments advanced on page number 3. Paragraph number 12 of page number 3, in which the councils have contended that it is less than 75%, that this is according to a report of the Telecom Regulatory Authority of India, that less than 75% of the Indian population possesses gadgets like smartphones. Less than 57.13% of rural India has wireless teleconnectivity, and less than 50% of the total population has subscription to wireless data. Your Lordship, in the light of these statistics, we can logically argue that when we talk of online education, it is not going to be accessible to a large chunk of the Indian population, especially the children in the disadvantaged groups, because we do not have the sufficient e-infrastructure and the connectivity for implementing that. Your Lordship, along with this, I would like to draw the bench's attention to the moot to the moot proposition in paragraph number 30 of the paragraph number 30 of the moot proposition. Here, the NGO is relying its arguments on a survey. It's relying for its arguments on a survey which is conducted by a state-aided institution, and the survey has clearly laid out how the state has failed to provide such infrastructure to the students. Your Lordship, under Part B, in paragraph 30, under Part B, that is the role of the state has failed to provide such e-infrastructure which it was liable to provide under the Children's Right to Free and Compulsory Education Act 2009. Section 3 of the CRFC Act, as it now shall be referred to, paragraph 3, according to moot proposition, paragraph number 24, paragraph 3 provides that it is the duty of the state that the state shall provide information and communication technology and facilities which are necessary for students and teachers. It is also the duty of the state to provide adequate training to the teachers and to provide e-infrastructure and economic assistance to education institutions to develop the means of education through internet. However, such obligations have not been met by the honorable by the Union of Hodu, and thereby the conclusions in Part B of the survey are very pertinent to note that the state has failed to provide online learning methodologies and the requisite training to teachers, and in the absence of all these prerequisites. Yes, Your Lordship, I sense a query.
No, see, you stated that you have the statistics.
Indeed.
From an agency which is associated with the state.
Indeed.
Now, if the state knows that this is the type of infrastructure that is available to the percentage of population, and still it endeavors to make a law that online learning should be made available to all children, don't you think your petition is premature? Without even waiting to know what the state is going to do, how it is going to provide the infrastructure, you have filed this petition challenging the law itself when an endeavor is sought to be made by the state government.
Your Lordship, the Council would humbly point out that the ordinance was introduced in April 2020, and these writ petitions have been filed according to the moot proposition itself. In paragraph number 29, these petitions have been filed in January 2021, and it was only after a committee, as stated in paragraph 28 of the moot proposition, it is a government committee which assessed the impact of COVID-19. It is stated that due to closing down of schools and switching to online learning platforms, there has occurred a learning loss, increased dropouts, and higher inequalities in the field of education. So it was only pursuant to the impact of the ordinance being observed in the country that these petitions were filed.
Correct. After that report, the government will make endeavor to see that everybody gets the facility. It can't happen in 24 hours.
Indeed, Your Lordship, that is true. And thereby, since we have seen that the government has not been able, so it is not only that it was now that the government was liable to provide this infrastructure. In 2009, when the CRFC Act was introduced, and Section 3 of the Act in the moot proposition itself states that government was liable to provide all this infrastructure since 2009. if it has not happened in so many years, now the urgency of doing so is even more in this pandemic, and thereby we have approached the Honorable Supreme Court to protect the right to education of the students and direct the state to fulfill its obligations.
What happens is sometimes if you rush to the court, you may even lose a good case. A classic example is 1978 Supreme Court 1296, a 7-judge bench decision in Prague Ice.
Yes, Your Lordship, the Council recognizes that that point. However, Your Lordship, I sense a query from you. Just this end.
21 capital A of the Indian Constitution said only primary education up to the age of 14. Why? State can't afford to give education to everybody. You can make a law because you have the power. Does the state have the resources to implement that law?
Your Lordship, again, I would...
If the state has no resources, can the Supreme Court by an order enforce that law? And the Supreme Court can't give effect to that. They can only make an order. There should be resources.
Your Lordship, that is a very pertinent point. However, the Council would point to the judgment in 1993 in Unikrishnan versus JP versus State of Andhra Pradesh. It was clear at that time as well that the state would have contended that we do not have the resources and thereby we have not made right to education compulsory for everyone. However, regardless...
That's why Indian Constitution only says 21A, only for
primary
14 years.
Indeed, Your Lordship, the Council is here...
Before making the law, you must think, not thinking after the law.
Indeed,
copying some other constitution is very good, but you should know whether it applies to you.
Indeed, Your Lordship, but sometimes, even as the example set by the Honorable Supreme Court, those examples have been such that the Supreme Court did in 1993 make the right to education a fundamental right under Article 21 itself. That too was also from of the age of 16 to 14. The government might have contended that after the economic crisis in 1992 and all, that they do not have the resources. But regardless, the Supreme Court did adjudicate that the right to education is a fundamental right under Article 21. Thereby, Your Lordship, these rights are such that they are so fundamental in nature to assure a right to life with dignity that the state is obligated to make sure that they are implemented regardless of their other economic commitments, which has also...
Not other commitment, they must have money. It is not a question of other commitments. They must have money. Between right to food and right to education, which will get preference?
Your Lordship, education would get preference.
Right to food.
Your Lordship...
First you must be alive.
You must be alive, you must be existing.
Yes.
I'm sorry, Your Lordship, the right to food would get preference. Yes. However, that right to food is also...
When this amendment was made, when this law was enacted, nobody thought about this COVID-19 pandemic. It is not mere education. It has destroyed the economy of the country. People have become unemployed. People are without food. People are migrating.
People are dying.
Now the only challenge is if you are alive, that's a great, if the government can help you to remain alive, that's a great service the government will be doing to the public. Afterwards, let us see education, employment, all other things afterwards.
Indeed, Your Lordship, that is the point.
Education, no.
Your Lordship, that is the point that we are contending that this ordinance is unconstitutional because it has been enacted without the government considering how would actually it benefit the students. And that is the grounds for its unconstitutionality because it is violating thereby the fundamental rights. That is exactly our argument, Your Lordship.
I am not able to understand. Your right is under the ordinance, and now you say you are challenging the ordinance itself.
No, Your Lordship, I would beg to disagree there. The right, these are two separate things. I would like to once again clarify. Issue second is regarding the unconstitutionality of the ordinance, which is making this ordinance unconstitutional because it is unreasonable. It is absolute in its term that all education should only be through internet and thereby creating inequalities in the country. The third issue, which is regarding the digital accessories and the tortious liability of the state, that is a separate issue which contends that the state should be made liable to provide digital accessories. So, Your Lordship, we are contending two separate things.
But if I have understood you, you're not basing your right under the ordinance, you're basing your right under the Constitution, isn't it?
Indeed, Your Lordship, under 21A.
Yeah,
read
please say
along-
that. Please say that.
That's why first question I put you was, what
Yeah.
is
I beg the pardon, Your Lordships, if that was unclear. However, while stating issue 3, the council had stated that tortious liability is being argued under CRFC Act read along with 21A. So, Your Lordship, that having regard to that, Your Lordship, the council would now like to move ahead with its arguments. So, Your Lordship,
just before we go to the next issue, what are the normal grounds on which constitutionality of a statute is questioned or questionable? Normally, what are the
Your Lordship, you were not audible clearly at the end.
normally, what are the grounds on which constitutionality of statute could be questioned? What are the grounds?
Normally, Your Lordship, the grounds are can be various. Like, firstly, that the enacting body was not did not have the legislative competence and the constitutional mandate to enact that ordinance. There can be the grounds of violation of fundamental rights there. Secondly, and that it goes beyond the scope of constitution, and such arguments can also be argued. So, Your Lordship, we are not contending this ordinance on the basis.
No. I just wanted to ask you. You have given the right answer. Yes. Please go ahead.
Much obliged, Your Lordship. So, Your Lordship, thereby we are contending that since this infrastructure does not exist, therefore this ordinance is violating the right to education by switching everything to online mode, and thereby, yes, Your Lordship, I sense it.
Now, on what ground are you challenging? Now, you mentioned to the learned judge the grounds on which you can challenge a law as unconstitutional. Now,
Yes.
your contention now is based on what ground?
Under Part 3, that it is violating.
Competence, I'm sure you're not questioning the legislative competence.
Indeed, Your Lordship, you are not.
So how are you developing your ground? What is the basis?
Your Lordship, as stated earlier, the grounds are that under Part 3 of the Constitution, these are violating the fundamental rights under Article 13 and Article 32.
Article 13 is not the thing. Article
Yes.
13 is when you trace it to some article, then you can say the law is violative.
Yes, Your
Yeah.
Lordship.
But
So-
now you're tracing it to which fundamental right, as the learned judge, Honorable Justice Kumar, asked you.
Your Lordship, 4 fundamental rights are being argued. I just argued how it is violating 21A, that is right to education.
Okay.
Now I move to the second limb of the argument, that it is how it is violating right to life. Your Lordship, I would invite your kind attention to page number 5 and paragraph number 21 of the arguments advanced, in which it is clearly stated that, firstly, right to life. In the Constitution, it is in the form of a negative obligation that the state shall not deprive anyone of the right to life. However, the Honorable Supreme Court has various times interpreted the right to life and interpreted along with directive principles such as 47, Article 47, and made it an obligation on the state and the duty of the state to preserve life and preserve public health in the country. Your Lordship, I cite the authority of Paschim Bang Khet Mazdoor Samiti versus the state of West Bengal, in which the Honorable Supreme Court held that the right to life includes the duty of the state to provide healthcare and hospital beds and other medical facilities when it is needed by the people. Therefore, Your Lordship, it is a positive obligation on the state. Now, I would contend how this ordinance is violating right to health of these children. So, this ordinance is basically, Your Lordship, violating the right to a healthy childhood of these children under Article 21. Your Lordship, here...
One minute, we strike down this ordinance.
Indeed, Your Lordship.
Then what happens?
Then, Your Lordship, the state makes efforts to provide education by fulfilling its obligation under the CRFC Act read along with 21A. By providing...
Which means?
How?
Your Lordship, the state makes efforts to provide digital accessories to those to whom these are not available. At present, this ordinance is only increasing the digital divide.
That's all right. That's why I said we strike down this article, this ordinance. Then what happens?
Then, Your Lordship, the state provides that...
Article 21 is there. All right. We will, according to Article 21, what is to be done? Education is to be given. They have to, schools have to be opened. They have to go there.
Yes.
Now, if they go to school, they may die. Children may die. That is the reason why it is closed.
Indeed, Your Lordship, striking down of the ordinance would not amount to banning online classes. What we are simply stating here that the ordinance in its at present is so absolute that it's unreasonable. This should be struck down. And in the third issue, we are contending that that the state should be made tortiously liable and made to provide digital access and those financial assistance to those who do not have the digital technology as of now, and make them provide education in that manner. The state, Your Lordship, it is not about only the digital education or the online classes. It is also violating the right to health, because students are made in online classes, as Dr. Om Press argues, online classes are something which are detrimental to the mental and moral health of the students.
What is the alternative that you have in mind? To go to an open class and invite death?
Indeed.
I mean, it may be, not that it should be, but it can be, isn't it?
Indeed, Your Lordship, that is not the case. Before answering your question, the council would seek the kind permission of the bench for an extension of time to answer these queries.
Yeah, please, so that we would be enlightened. Yeah, please.
Much obliged, Your Lordship. So, Your Lordship, my argument is that once this ordinance is struck down, and according to the third issue which we are arguing, the state is made tortiously liable to provide digital access and free digital aid to the students who are in need. Yes, Your Lordship.
Sorry, I think you're mixing up. That would again only foster this online education. It would not make it a more healthy education as you contend, isn't it?
Your Lordship,
if you digitalize, you will still have online education. Fine, that's one aspect, maybe. But it would still not give you the healthy education that you have been contending for. And this would again still be violative of public health as far as your contention is concerned. So where do we go?
Your Lordship, we go there because at present, what the ordinance is
where do we go?
Your Lordship, this ordinance is not unconstitutional because it is providing for online education. This ordinance is unconstitutional because it is making the online education in such a compulsory and blanket manner that all students from smaller ages of 4 or 3 to up to 18.
I'm sorry, I think what you intend to contend is that this is bad because it makes a divide, not
Indeed.
Because it makes it compulsory.
Your Lordship, there are both the grounds. It is making it compulsory.
By making it compulsory, what is the vice in that? What is the vice in that?
Indeed, Your Lordship, the council is coming to that.
Unless you say health, as you have been contending. But what is the alternative for health? You have to go to a regular school. And regular school in these days, I think everyone knows, just as Kumar just now mentioned, the alternative may be dying instead of studying. I don't think any state can afford to go that way. Neither would you contend before a court that a court must give such a direction.
It's a right to life.
Yes.
Indeed.
Right.
Indeed, Your Lordship.
You can't take away the right to life by asking them to come to school, sir.
Yes.
Indeed, Your Lordship. The council is just seeking 2 minutes to address all your concerns.
Sorry for interrupting, but please enlighten. Yeah.
So, Your Lordship, the council firstly is unconstitutional because it is creating digital divide. Under Article 14, it is not providing equal protection of law, equal opportunity. It is placing unequals at an equal level. That is something which is very clear, and that makes it arbitrary. Firstly. Secondly, Your Lordship, what this ordinance is doing, it is making online education compulsory. It is for all educational institutions. It is making it compulsory for all of them to provide online education. That means children of all ages are being made to learn from online education. That is something which is detrimental to their health because, firstly, online education to children who are of smaller ages, that is not good for their health. That is actually hampering their mental development, and secondly, their moral development, because they might get into the trap of online abuse or adult content in online mode. Thereby, Your Lordship, this ordinance is arbitrary in its absoluteness. When we say that provide digital accessories, free digital accessories to students, we are saying that the state must do it in an intelligent manner so that the students of right age group get the right kind of access and the right kind of education. This ordinance is not doing that. That is our contention, Your Lordship.
Okay, fine. The next speaker.
Your Lordship, the council would just like 1 minute to sum up his arguments and just finish with his argument.
I have understood your argument. Don't worry. We'll go to the next speaker.
All right. Much obliged, Your Lordship. Thank you.
Greetings to the honorable bench. The council would now be addressing the third and fourth contention. The third contention is with regards to the tortious liability of the state, which says that the state can be held tortiously liable for its failure to act according to the CRFC Act, read with Article 21A of the Constitution. Now, while this argument has 4 limbs, before moving to the sub-contentions of this, the council would just like to direct the attention of this honorable court to the fact that the statute that we're talking here, that the CRFC Act is actually a social welfare legislation, as has been held in the case of Ashok Kumar Thakur versus Union of India, that it is social welfare legislation and it has to be read as a child-centric legislation, which has to be the priority when understanding that legislation. Coming to the arguments of how the state can be held tortiously liable, as it has been, there are 4 limbs to this argument. First, that there exists a duty on the state to provide free and accessible education. 2, that the actions of the state constitute as a breach of its duty. 3, that the breach of the duty by the state has led to consequential damages. And 4, that the state is liable to provide financial assistance and free digital accessories for ensuring universality of education. Now, when we come to duty of state, as has been held by the Honorable Supreme Court in the case of Jayalakshmi Salt Works Private Limited versus State of Gujarat, it is mentioned in paragraph 37 of the arguments advanced. Tort simply means any breach of duty which leads to damage. Now, this breach of duty which is fixed by law, and the basic ingredients of tort do include injury and damage due to a failure to observe legal duty. So all of these criteria are what will be established in my further arguments, that how the duty existed, there was a breach, and it then led to damages. Now, when we talk about duty, I would be establishing the duty in various manners. The number 1 being the constitutional duty arising out of Article 21A, which has been held as a fundamental right. Now, Article 21A in various judgments by the Honorable Supreme Court has said that it is of utmost importance and it is something that cannot be suspended even during an emergency, if any. Now, when we refer to the case of Unni Krishnan versus State of Andhra Pradesh, the Honorable Court did include infrastructure and said that under the right to education, that the right to education does include providing the infrastructure for availing that right. And the state is under an obligation to remove any financial barrier that may act as a hindrance in exercising the right to education. Furthermore, when we talk about the statutory obligations of the state, the CRFC Act, while the original CRFC Act mentioned in the Indian...
You're relying on Unni Krishnan case. Relying on Unni Krishnan case, the Indian Parliament enacted 21A. But the law here is not
different.
21A. You have not read, the persons who enacted did not read Unni Krishnan properly.
Your Lordship...
You can't simply impose. The state should be able to withstand the weight. Therefore, they said primary education. If you had said primary education, you could have done something. You say whole education. That was not in the contemplation of either the party, the judges, or anybody else. That's the blunder you have committed in when drafting the Constitution.
Your Lordship, while we contend to the fact that
whether it's a judgment of the Supreme Court or a constitutional provision, it should be capable of being implemented, is it not?
No. Yes, Your Lordship.
Without proper thinking, if you pass a law which is incapable of implementation, what will the court do?
Your Lordship, as has been held in the various judgments of the Honorable Supreme Court, that a state is bound by its own statutes. Now, the original CRFC Act, which exists in the Indian scenario, does not include providing ICT to students. However, as mentioned in the MOOT proposition, in the state of Hudu, the CRFC Act does contain Section 3, which contains certain provision that the state has to provide internet and communication technologies, digital accessories, and financial assistance to students. Now, this act was passed by the Parliament in 2009. And considering that the state itself has passed this statute, it needs to be the court needs to hold the state bound by its own statutes, since it was an action of the state itself that this statute came into the picture.
Did this statute say what is the time limit within which they will do all this? Or they said instantaneously with the passing of the act, or on the day the act came into force, it will be provided?
Your Lordship, it was not contended that the date would come into force. However, since the statute came in 2009, And till date, it has been 2021, and the state has not even made efforts to provide these technologies to students. The state should be held liable in this present matter. When we also talk about breach of duty by the state, when we talk about breach of duty by the state in tortious liability specifically, whenever there exists a duty, there is an element of reasonable care. And we understand that reasonable care needs to be taken. However, in the present scenario, the state has not also been taking reasonable care, since there existed a digital divide even before the advent of the pandemic. And since this duty also existed before the advent of the pandemic, while we do agree to the fact that pandemic was not something which was foreseeable, however, if the state would have complied with their duty even before the pandemic and would have actually stuck to its obligations, the damage that the students are facing during the pandemic would not have been to such a severe level where their fundamental right to education would be something which would be hampered. In the present scenario, when the state does talk about different guidelines that the state has issued for imparting education through different means, be it radio, television, the issue here arises as those guidelines are simply advisory in nature. However, the law that the state does, the ordinance that the state has incorporated simply talks about e-education or internet education and not other means of education. The other means are simply through guidelines which are advisory and which will not be implemented or enforced properly, since they are of advisory nature in this present regard.
Just a passing question. You have been emphasizing on the ordinance which was passed, as you said, in April 2020. Is it still remaining an ordinance, or has it been enacted into a law, into an act?
While this is something that the proposition does not clarify us upon, that whether it is still an ordinance or it has been made into a law, it is under the assumption.
An ordinance is also law. That's why I corrected by into an act. Yeah.
As in, it has not. We don't know if it is still an ordinance.
Fine. Okay.
We in the brief of its duty.
If no law is passed, there is no ordinance. What is that you are challenging?
Yes, Your Lordship, I did not hear you.
Well, after 6 months, is it not?
Your Lordship, in the issue of tortious liability, we're not challenging the ordinance, which was challenged in unconstitutionality. In the issue of tortious liability, we're holding the state tortiously liable for not fulfilling its obligations, which existed even before the pandemic and exist even during the pandemic, which the state needs to fulfill.
What is your prayer on the ground that the state is tortiously liable?
Your Lordship, with respect to tortious liability, we ask the Honorable Supreme Court to hold
That is this court.
Yes.
We ask this court to direct the state to provide financial assistance and free digital accessories for ensuring universality of education.
To whom?
To the deprived section of students who do not have access to these technologies and internet for availing the right to education.
Up to which level then?
Your
even postdoctoral research, they are also students.
Your Lordship, since this ordinance is contended specifically with children, it directs to providing this for ensuring universality of education to children up to 18 years of age.
No, but is it so specified? Because your 21, unlike the Constitution of India, speaks of education for all. Does it? I mean, I don't know. Does it specify it's only up to 18? You must enlighten.
Your Lordship, it does not specify the age. However, the arguments are framed in such a way that it does refer to those section of students.
You're satisfied if up to that age it is given. That's what you mean.
Yes, Your Lordship.
Now you are talking about damages and you are talking about facilities you made available. Do you want both or one?
We want facilitation as it is not possible, as we understand the economic constraints, and it is not possible to provide damages to every student, which is why there is no compensation being sought in that regard. However, the state is directed to provide these facilities so that right to education can be availed.
So therefore, will not the other side argue that it is not actually a challenge to the constitutionality of the act? It is only that it is not being implemented properly.
Your Lordship, the ordinance that was being challenged is not only on the grounds of the divide, it is also the grounds for 21A as well as 14 both. However, the prayer that I just now said was in regards of tortious liability. However, the prayer in regards to ordinance is that it should be declared unconstitutional, as till the time the digital divide is curbed, even if the fundamental right of one student gets violated, it would still amount as a violation of fundamental right. If your lordships may permit, moving to the breach of duty by the state, the petitioners in this present matter do contend that there has been a negligence on the part of the state. The basic, as it has been held in the case of Common Cause versus Union of India, the basic ingredients of torts do include mistake, defective planning, and failure to discharge public duty. When we talk about negligence in the present scenario, negligence, as has been defined and which definition has been upheld in various judgments of the Honorable Court, that negligence is the breach of a legal duty to take care which results in damage undesired by the defendant to the plaintiff. With regards to the digital divide that existed, there have been various national reports which claim that the digital divide exists. And very recently, the letter by the Honorable CJI to the Telecom Minister does even point out further to the digital divide that exists in the nation. The Honorable Court also, with regards to even though separate case, however, the case during the pandemic, when the court was talking about the vaccination policy, even then the court pointed out the digital divide that exists and that needs to be curbed by the center in this regard, even during the pandemic. When we refer to, even though we do not contend that there have been any malified intentions, we do agree that the state did have bona fide intentions in all of
in what?
We do agree that the
in what?
Obligations and
no. State had no malifides. It was bona fide in what?
We say that in the different actions by the state with regards to its obligations, the intentions were not malified, they were bona fide. However, even as it has been...
You must be very careful in the expressions that you use.
Yes, you're
right. Malifides, whether you're talking of actual malifides or legal malifides, if you're in a challenge to a law, malifides is absent. As Chief Justice Chandrachud said, transferred malice is unknown in the field of legislation. 85 Supreme Court 555. Transferred malice is unknown in the field of legislation. So you can't open your mouth about malice when you're talking of an ordinance.
Your Lordship, the council was simply contending that even for the
so as lawyers, please be very careful with the expressions that you use meticulously.
Definitely, Your Lordships. The council was referring to how there are no malified intentions and there are actually bona fide.
And again, when you say malified, you can't attribute malifides to the government as a whole in the state. You can attribute malifides to a person, a group of people, unless you say legal malice. Legal malice is totally different from the kind of malice that you're talking about.
Definitely, Your Lordship. In this present scenario, even if the state did not have any knowledge of the tortious liability that could arise or the damage that could arise, even then, as has been held by the Honorable Court in the case of Vishnu Basudev versus THS Pierce, that even if that knowledge may not be available in every instance of tortious liability which arises out of violations of a public duty. However, if there is damage, then the liability does arise. Moving to the third limb of this argument, where consequential damages have been caused due to breach of duty by the state, as has been elaborated above, the violation of the fundamental right to education. And since this right to education is specifically being affected of those students who belong to an economically weaker section due to the lack of facilities, it also violates the right to equality in this present scenario, where only the students who do not belong to economically weaker sections are the ones who are not being able to avail the right to education. Coming to the next part of it, how the state is liable to provide financial assistance and free digital accessories for ensuring universality of the education, as has been held in an ongoing case. However, the judgment of the case is not yet available. However, the daily order by the Honorable High Court of Karnataka in an ongoing case does direct the state to provide financial assistance and free digital accessories even during the ongoing pandemic to ensure the universality of education, as was remarked by the...
We are not bound by that judgment. That's the High Court. You're before the Supreme Court.
Yes, Your Lordship, even though the court is not bound by that judgment, considering that a pandemic is a novel situation and there's not a lot of legal precedent that arise, which is why there's a reference to the High Court judgment in this regard.
Of course, you can always bring it to the notice.
Coming to another case of the Jayalakshmi salt case, where it was held by the Honorable Court that the concept of duty in a society keeps on changing as per the needs and demands of the society. Considering that pandemic has led to a need of online learning and has led to this demand of internet and digital accessories being made available, even though if this duty did not exist earlier, it exists now. And the state should hence be made liable to provide these facilities to the students. If Your Lordship may permit, and if there are no further questions, the Council would now seek the permission to move to the next issue with regards to the international commitments of the state.
Please.
The next issue being that the policies of the state of Hoodoo are in violation of international treaties and agreements.
Just one moment there. When you talk of international obligations, are the international obligations automatically binding on a state?
No, Your Lordship, the international obligations are not automatically binding. However,
Under what circumstances would they become binding?
They would become binding if they have been ratified and they've been incorporated in the domestic law.
Yes.
Which in the present scenario, we would be establishing how they have been incorporated in the domestic law. In the present scenario, when we look at different international treaties and their ratification, the Convention on the Rights of Child, as well as the International Covenant on Economic, Social and Cultural Rights, both of which talk about education as well as its universality, have been incorporated in the domestic law through the Article 21A as well as the CRFC Act. The UDHR, even though it is not binding in general, however, the UDHR has been fundamental in forming the Part C and D of the Constitution, as has been mentioned in the MOOT proposition. The UDHR has also been referred to by the Honorable Supreme Court of India as a model code of conduct as recognized by the UNGA, which can be referred to for the interpretation of domestic laws. Through this, we understand that that these obligations have become a part of our domestic law as well, and hence they become binding on the state. The international commitments of the state of Hoodoo include 4 essential features, that is availability, accessibility, adaptability, and acceptability. All of these features do ensure that the state does ensure that all the students do have access to digital education as well. Even the guidelines that have been, even the general comment on the ICESCR during the pandemic does talk about how this can be domestically, how the implementation can be done in a domestic situation, and how minimum education standard needs to be maintained even during such a situation by ensuring that digital education is available to all. And digital accessories have been available to all to reduce the educational inequalities among the different classes of learners. Even if we refer that the pandemic is an exceptional circumstance and there are certain practical limitations, even the WHO has issued certain guidelines during the pandemic with regards to education of students and how that needs to be continued. These guidelines do ensure that the state does establish a continuity plan for various mental health programs and psychological support for students, teachers, and school staff. The state is also required to review and adapt contingency plans to ensure essential school-based health services. The state is also required to establish a committee for continuous monitoring and evaluation of the situations in schools in collaboration with the education.
I think the voice is lost.
Your Lordships, I guess my co-counsel's connection is lost. I'll just try to get
Please.
in touch with her. Kindly grant us a minute.
Please.
I apologize, Your Lordship. There were some connectivity issues, which is why I got disconnected. Coming to the guidelines by the WHO, in fact, the government's own commission report during the pandemic, which talks about how there has been an academic loss due to lack of mobile phones, internet, as well as digital accessories. The own government's commission report talks about this impact. So considering all of these features, it becomes extremely essential that the government be held liable for its duties which existed even before the pandemic. And now, since those duties have been the importance of those duties has been highlighted even more due to the changing needs and circumstances of the society. The international commitments of the state do also incorporate these duties even during the advent of the pandemic, which is when the responsibility of the state to take reasonable care is heightened in the present circumstance, as education is something which is not supposed to be suspended even during an emergency, if any, even though the government has not declared an emergency per se. But even if we were to treat it as an emergency, Article 21 is not supposed to be suspended.
Madam, in this regard, your contention is that this ordinance, which is a policy of the state, is violating the international treaties.
Your Lordship,
How are you saying that there is a violation of international treaties? In what regard?
Your Lordship, we are not saying that the ordinance violates international treaties. We are saying that the state's actions with respect to not fulfilling its international commitments by not providing the adequate infrastructure, digital accessories, ensuring universality of education, all of these things violate its international commitments. So even though
therefore, again, you are countering your own argument. It is not that the policy is bad, it is that they are not able to implement it properly.
Your Lordship, the state, for this regard, does not have a policy to be able to implement these things. The state is not providing these facilities. So even though the statute does exist, the state has not complied with its statutory obligations in this regard, which is why we are holding the state liable for that.
So therefore, the other side will definitely say it is not that the policy is bad or the law is bad. It is only that the state has failed in implementing it properly.
Your Lordship, with regards to the ordinance, which the other side may contend is with respect to implementation. However, it has been held that if even though a law does not directly discriminate, however, if it's in its effect, if it is discriminating, or in its effect, if it is leading to any violation of fundamental right, it would still be unconstitutional as a direct effect of that ordinance. And a direct effect of the ordinance in the present situation is leading to a violation of the fundamental rights of the students.
But more than the attack on the ordinance, the whole thrust of your case, as we can understand it, is that you want certain directions to be given for better implementation and the state to do something more. I mean, that seems to be the whole thrust of your case.
Yes, Your Lordship, as even mentioned in the prayer, if I may be permitted to narrate the prayer, if Your Lordship may permit, I would narrate the prayer.
Yes.
Therefore, in light of the questions presented, arguments advanced, and authorities cited, the petitioners pray to this Honorable Supreme Court to adjudge the following order and declare: 1. That the 2020 Learning Ordinance passed by the Centre as unconstitutional. 2. That the state is tortiously liable for its failure to act according to the CRFC Act, read with Article 21A of the Constitution. 3. That the state to provide financial assistance and free digital accessories for ensuring the universality of education. 4. That the policies of the state of Hoodoo are in violation of international treaties and agreements. In the alternative, pass any other order of relief as the Honorable Court may deem fit. For this act of kindness, the petitioner shall be duty bound forever. So in the prayer, we are not just talking about the ordinance, however, we are also talking about the tortious liability and how the state needs to be directed to provide certain facilities to ensure the implementation happens.
All right. Yes.
In case there are no other questions, this is the end of the arguments from the petitioner side.
Yes.
Much obliged, Your Lordship. It was an honor arguing before this court.
Now, just one question, if I may ask you. Now, if you're not so much bothered about the unconstitutionality of the ordinance, now these positive directions are virtually, can you have those implemented in the absence of a law?
Your Lordship,
or is your argument that the present law itself needs better implementation?
Your Lordship, considering that we understand that the digital divide cannot be curbed in one single day, which is why even though we ask this court to direct the state to take positive measures for curbing that digital divide, however, till the time that digital divide is curbed, the education needs to be provided through different means as well, even though physical classes are not something which can be resumed. However, even in online mode, distant learning, there should also be the incorporation of different modes of education, such as television and radio. While the government has issued guidelines for this, those are only advisory guidelines, and the government has not incorporated that into the law. So, since the law only talks about internet education, that is why we are challenging its constitutionality.
See, this is a problem which the government, the public, the court are all facing for the first time, right? Judges decide cases not by looking forward, only by looking backwards. You don't have any precedents at all. Now, how are the judges competent to issue directions to sort out this problem when they have no first-hand experience of anything?
No wherewithal.
Your Lordship, even
I will judge, I can pass an order, fine. Power is conferred. But before passing an order, you must have some basic information. Now, for example, you are referring to WHO reports. You are saying every month their report is they themselves contradicting it. So you can't act on that.
Conditions are so different every day.
For the court to pass a just order, there should be material which is truthful, reasonable. Now the foundation itself is not there.
Your Lordship, in the present matter, even though the pandemic is a new circumstance and this is something which is arising for the first time, the Honorable Court has, in various instances, when a law is something which was discriminatory among students specifically, there have been various laws, especially
if we come to the conclusion it's discriminatory, there is no difficulty. For us to come to the discriminatory, what is the material? What is the experience? What are the facts?
Your Lordship, since
if we wrongly come to the conclusion it's discriminatory, what is the damage done?
Your Lordship, considering that digital divide is something that is known to the...
even if we declare it as discriminatory, does it solve your problem?
Your Lordship, the subsequent part of the prayer, which also directs positive measures, when both of these things come together, then the problem is definitely getting solved in a much efficient manner. As obviously it won't happen in a day. However, positive steps when taken with respect to that would ensure that at least it is in a positive direction, that yes, the problem will now be curbed in the future, or at least positive measures are taken.
What the courts have done in such circumstances is not to pass any judgment. You understand? Issue a direction, find out how much it is followed, how much it is not followed, why it is not followed. Continuing mandamus. That is the invocation bias. Nobody knows what it is. I may say something which may, if it is implemented, something else will happen. The aggrieved person will come to the court then. So we can only do, what can we do is we can monitor. We can issue continuing mandamus. When we are wrong, we can withdraw. Where we are strong, we can go forward.
It can be corrected at every stage.
Your Lordship, considering that in the present matter, if this particular law direction is not issued, it would result in a continuous violation of fundamental rights of the students, as they would not be able to regularly the digital divide that exists. It would just worsen the impact of that digital divide. So in that respect, this order needs to be done, and if the government does not follow, then that is not something that we can predict at this stage, that whether the implementation would be right or whether the government would comply with the orders in a proper manner or not.
Now, as Honorable Justice Kumar has said, would you commend as a prayer a continuing mandamus from this court?
Your Lordship, that when we are directing the state to provide financial assistance and free digital accessories, it is in a manner of mandamus as well that we direct.
That's a final mandamus. The case is closed. Now we are talking of a concept of continuing mandamus, which when the case is not closed, the case keeps on. Judges retire, go, they even die. Succeeding judges take care of it, and their successors take care of it.
Your Lordship, in the present scenario, yes, that would be beneficial, even if the ordinance is something which is debated upon. However, if the state is immediately directed to provide financial assistance and free digital accessories, it would definitely benefit the present situation of the students in a manner, even if the law is something which continues to be debated upon in the future.
Okay.
Thank you. Thank you.
Much obliged, Your Lordship.
Greetings to the bench. If the
Just 1 second. Just 1 second.
Just one minute from me also. I want to connect this with the power cord. Please give me 1 minute.
Indeed, Your Lordship.
Yes, you can go ahead. Yes.
Greetings to the bench. The counsel for the respondent seeks this court's permission to address this bench collectively as Your Lordship.
Yes.
Now this is which team? The other one was team 30. This is
Team 03, Your Lordship.
03.
Much obliged, Your Lordship. May it please the court, I'm the counsel 03S1 representing on behalf of the respondent state of Hodu. My submissions will address the issue of constitutional validity of the 2020 online learning ordinance. Your Lordship, if the court is well versed with the facts and jurisdiction of the case, I'd like to proceed with the issues in question.
Yes.
Much obliged, Your Lordship. The first issue, whether the 2020 online learning ordinance, to answer this particular issue, Your Lordship, we have to look at when a ordinance can be unconstitutional. It can be unconstitutional on 2 grounds. That is, first is legislative incompetence, and second is the violation of fundamental rights. To answer the aspect of legislative incompetence, Your Lordship, I'd be explaining in 2 folds. First is that the shift to online education and the subsequent close down of educational institution to be completely valid. And second, Your Lordship, the viability of online education and its existence before. To start off, Your Lordship, the current facts of the situation is that COVID has infected over 17.7 crore worldwide and has killed over 33 lakh deaths, according to the latest survey, latest Google reports. Why am I quoting this is because, Your Lordship, it is a pandemic that is a disastrous one and has been it is an unforeseen and unprecedented situation which has not been seen for over 100 years. Which is why, Your Lordship, we as the government had to come in and put reasonable restrictions on lockdown and subsequently close down non-essential services. Your Lordship, the powers that were exercised were under the Epidemics Act of 1897, Section 2, which states that the central, when it is of opinion that the normal measures are not enough to an area and threatened with the outbreak of an epidemic, can put reasonable regulations and restrictions. After declaring COVID as a notifiable disease under Epidemics Act of 1897, it came under the ambit of Disaster Management Act Section 2D, which defines disaster. Now, Your Lordship, disaster here will include the term epidemic and will grant us huge comprehensive powers with the introduction of Section 6 of the Disaster Management Act 2005, thereby making sure that our closing down of educational institutions and the putting the lockdowns are completely valid. Secondary aspect, Your Lordship, we have shifted to online education with the wordings of Article 21A under the Indian Constitution. Article 21A talks about how the state has to provide free and compulsory education to the age group of 6 to 14 as the state may by law determine. Your Lordship, the words that has to be emphasized here is as the state may by law determine, which was resonated in the judgment of Justice for All versus NCT Delhi, where the Honorable Court had held the fact that as long as the education qualifies that basic standard of education, it is free to depart from the mode of education, which is why, Your Lordship, we contend that the shift to online education is completely valid, making the aspect of clear, making our proportions actions clear in the proportion of legality completely valid. Secondary aspect is the viability of online education and its existence before, Your Lordship. To understand the grassroots level of the inception of internet in education, we have to look for 1989 Convention of Child's Right. The 1989 Convention of Child's Right had recommended innovation in education, which introduced the fact internet in education. Now, Your Lordship, internet plays a key role and has been on a subsequent rise and has played a very much important role with introduction of e-learning and distance learning. The factors which are contributing to the e-learning and distance learning programs in India is currently due to the low-cost 4G data available with an estimated rate of 10.55 rupees per GB. Secondary aspect, Your Lordship, is that the growth of smartphone devices, that is the penetration, standing at a more than 60% by the year of 2022, as accorded by the iMobile Research Institute. Similarly, Your Lordship, the cost of availing the professional course in a online form is much more cheaper to the traditional mode of online education, which is why the distance learning and e-learning progress is on the rise. Now, the secondary aspect,
before you proceed on those lines, with the type of argument that was made by the learned counsels for the petitioners, and we have found that their thrust is more regarding the manner in which this law could be implemented. So therefore, please don't labor upon the constitutional aspect of it. Please concentrate on the other argument that without preparedness, the state government has come up with this law. And therefore, if we challenge the law on these grounds, saying that it was done without preparedness, the state doesn't have the financial capacity to provide for infrastructure, and therefore, without formulating proper rules, they should not have come up with this ordinance. Please concentrate on those lines. Yes.
Indeed, Your Lordship. The concern is totally understandable, and to which which is why I started with the with the grassroots level inception of internet, because to explain that the aspect of online education isn't something new but has existed much before. Second to coming to your point, Your Lordship, the online education viability concerns with regards to viability is gradually on the rise because of several technological factors. As you can see, under the Saubhagya scheme proposed by the government in which was completed in rural, which proposed 100% rural electrification in the 2009, have currently achieved that target, and making sure that the first barrier to towards the access to internet has been completely removed. Second of all, Your Lordship, coming to the aspect of the smartphone penetration or the internet penetration that is standing, an estimated that 45% of Indians are currently have internet accessible to them. Similarly, this 90% of the people in India have some sort of access to some sort of device by the year of 2022. All these are accorded as the government portals, and
if you accept that even 10% don't have access to internet, then how are you going to justify your ordinance?
Your Lordship, will have to justify the ordinance via the grounds of doctrine of necessity, Your Lordship. It is to avoid the greater harm of impacting all the other students of education, which is why we'll have to deprive a few fundamental people of their education right. As was
then,
held.
What will you do? What will you do while you announce the examinations to these children aged between 6 to 14? When you announce the examinations, and some of the underprivileged children don't have access to internet facility, and they have not been taught.
Indeed,
how do you expect them to write the examinations compared with the other students who have already been taught online?
Indeed, Your Lordship, your concern is completely understandable, but the part of the issues that we have solved is we have not shifted to online education completely, but the it's a temporary phenomenon. As soon as the COVID guidelines relaxes or the vaccination has been taken place to almost all the students, we will make sure that the unlock 2.0 is in a gradual process, and making sure that students who follow the COVID guidelines will be able to access these in these schools and educational institutions with the hybrid form of education system. And similarly,
COVID guidelines.
The ordinance was brought up in April 2020.
Indeed, Your
So
Lordship.
the students had to write their examination in May-June 2021.
Indeed, Your Lordship.
Now, in the manner in which the pandemic has spread, continued to the next academic year, haven't you failed in providing necessary infrastructure and a common platform to all the students so that they will be educated equally and they will be ready to write the examination?
Absolutely, Your Lordship. To answer that particular aspect, we would like to state the progress that has been made by the state governments on this end. For example, Your Lordship, West Bengal has proposed 9.5 lakh educational devices to all the students in their state. Even though the concerns with the financial state that they are suffering is totally understandable. Similarly, Your Lordship,
no. See, this is a moot court competition. We are not concerned with the actual facts and figures. We are concerned with the legality and the questions raised in the moot. So therefore, you don't try to say that we have made facility. That is not what we want to. We want to hear from you how this ordinance could be sustained. When you admit that there is no rules framed to implement this.
Indeed, Your Lordship. To explain that, Your Lordship, as I've already stated, the doctrine of necessity, where in the case of Justice S. Rangarajan versus P. Jagjeevan Ram, the court had held that if the fundamental rights can be violated, if the the societal change and the climate change requires them to do so, which is what this temporary phenomenon is causing, Your Lordship. If indeed the students' right to fundamental rights such as Article 14 or Article 21A is being violated, will be guarded under the defense of doctrine of necessity, and India that would be the argument, Your Lordship.
You mean to say a necessity can justify violation of a fundamental right? I mean, is that the principle? I'm not very sure what you're trying to argue.
Indeed, Your Lordship, if we are acting in the bona fide manner, and if our failure has acted in carrying out these provisions, it will come to our rescue and
you're trying to justify the manner of implementation. That's one thing. But as a proposition, you said the doctrine of necessity will come to your aid if anyone comes to court on the ground of violation of fundamental rights.
Your
I'm
Lordship,
not able to understand that.
Your Lordship, we are only contending doctrine of necessity because our current financial resources do not allow us to do so, and furthermore, the COVID-19 pandemic has crippled the economy to a lifeless state. And if we in the matter of right to health, if we which triumphs over the right to education, this will lead to a much more larger legal implications, Your Lordship, which is why we contend the same. If the court allows me to continue, yes, much obliged, Your Lordship. Coming to the aspect of the state of emergency, Your Lordship, the COVID pandemic has been on the rise with the second wave of pandemic, which has seen a lot of hysteria and lawlessness that is being created, which can be seen in many isolated events where mob of people were attacking medical suppliers to get that oxygen supplies or the necessary equipments, which is why, Your Lordship, it is creating a state of lawlessness, and it can be regarded as a coronavirus-driven internal disturbance. Now, Your Lordship, according to the Sahakarya Committee report, an internal disturbance will include the terms epidemic and a natural disaster, which is why a ground for declaration of emergency on the same can be legally valid. Now, as to why I state that, Your Lordship, is because right now the situation is so that we'll have to bring in the contention of emergency and declare and enforce that the fundamental rights that are being violated cannot be enforced in the court of law. Here, Your Lordship, the national emergency will be proclaimed under the proclaimed under the ordinance justified with the doctrine of necessity, and bringing in the ambit of Article 358 and 359 with
2 points. Sorry to interrupt you in the tracks.
Indeed, Your Lordship.
One is you're telling the court what you intend to do. In the court, when there is a challenge, you have to only justify your action. That's one thing. But more importantly, you're talking of invoking Article 358. Would 358 come to your aid in the case of Article 21?
Your Lordship, as we have already contended...
Unless you're talking of a pre-1979 situation. 42 years have gone by.
Your Lordship, as we've stated, the response...
Please answer this pointedly. Sorry. I hope you got my question.
It will not, Your Lordship. The Article 21 will not be...
and you have not declared emergency. You have not declared.
You have not declared an emergency.
Understand? Therefore, those articles are no application.
Yes. This is what you would perhaps contemplate at some future date. That's no argument.
That is not an answer to the attack.
Indeed, Your Lordship.
You do whatever you want to do, but you have done something that will justify.
Justify.
Indeed, Your Lordship. I was just trying to say that the current situation does demand the proclamation of emergency.
That is rhetoric than a legal argument. I mean, in Parliament, it can be raised, not in a court. Please.
That is not an argument which is open to you. You do whatever you want. We are not coming in the way. Now, what you have done is under challenge. That's all.
That's understood, Your Lordship. If the court allows me to move on to the next issue. Now, the question is whether the state is tortiously liable for failure to act according to the CRFC in Article 21A. So, Your Lordship, we have to...
So do you, I mean, have you concluded your arguments on the constitutionality of the ordinance? What is your final, how do you sum it up?
Your Lordship, the constitutionality part, as we've already stated, does not arise unless there is a legal incompetence and there is violation of Article...
the petitioners have not even whispered about competence. You are fully competent. It's granted. But it's only a question of violation of fundamental rights.
And indeed, Your Lordship. And as we've already reiterated that the doctrine of necessary does grant us that provision when that a societal change or a climate change, if it requires the violation of fundamental rights to avoid a greater harm, it will be reasonable to do so. And which is why, Your Lordship, if this present ordinance, which is done in an act of good faith to avoid the greater harm of education violation of all the students, then we are not liable for the same. And
what is your authority for this proposition, if you have?
As I've quoted the S. Rangarajan versus P.
That was a different thing. That was about banning a film, isn't it?
Indeed, Your Lordship. But
can you just? I'm sorry, but can you just point out the exact portion of the judgment that you want to rely upon in this case?
Indeed, Your Lordship.
Jagjeevan Ram, Rangarajan, yes.
If the court allows me a moment,
please.
Your Lordship, if the court can refer to the paragraph number 4.
Please read it. Just the sentence, which you want to rely upon.
It states that recognizing the state authorities in that case, the censor board should be responsive to societal change and prevailing climate, and any restriction on fundamental rights could only be justified on the avail of necessity.
So there it was the situation was the opposite, that you should not interfere with fundamental right, the right of freedom of expression. The case was that, and this court upheld the right, isn't it?
Indeed, Your Lordship. But they also told that unless it is an avail of necessity, you should not encroach upon it. And currently,
that is in the context of 19(1)(a), where under 19(2) you have the power to impose reasonable restrictions.
Indeed, Your Lordship.
Under Article 21, do you have that? Now the challenge is under Article 21. Forget 19.
Now the challenge of this act is in its implementation. You have passed a wonderful act.
Yes.
But in practice,
What is it happening?
Discrimination.
What is happening?
Your Lordship, I'd like to beg to differ from what the petitioners have quoted. They have not relied upon expressively on Article 21A or 21 while quoting, but have relied on Article 19 and 21A, upon which the Article 21 right to health will triumph over those other two articles, which is what our contention is, Your Lordship. Right to health is of the paramount importance at current situation, and we would much like to safeguard every single citizen's right to health more than the right to education.
Okay, fine.
Much obliged, Your Lordship. Coming to the second question, Your Lordship, the state is not tortiously liable because of the two main aspects. When CRFC Act read together with Article 21A gives two aspects, that is fair chance and access to education. To explain how we as the government have explained, we have given fair chance, Your Lordship, I'd like to rely on the government survey, government report by the Saubhagya scheme, where we have achieved 100% rural electrification. Similarly, I would also like to rely on the Pragyata guidelines that the government has stipulated for the guidelines to be followed. Your Lordship, in this, according to the present circumstances of the child, the education will be given. If the child has a basic phone, he will be given a textual conversation. If the child has a TV, he will be given a television form of education. And we've also introduced free way of DTH, that is Swayam Prabha, which basically gives over 32 channels and 12 different languages, and for the class of 1 to 9. Because of this, Your Lordship, every aspect of fair chance is being trying to reach out. The complication of its economic resources will be explained in great detail by my co-counsel, which is why, Your Lordship, we can see. I'm trying to contend that we have achieved a balance between providing online education and online education and other economic aspects of this nation, which is why, Your Lordship, we have provided the fair chance. Second aspect of coming to access to education, Your Lordship, with the introduction of National Education Policy 2020, we have invested over 887 crores in the promotion of online education, and we have invested over 57 crores in Samragya Shikshana Yojana, which trains the teachers to adapt to the online education system. So the petitioners, while claiming that we have not trained the teachers, contentions become redundant.
Learned counsel, that is why we said we are not actually concerned with the statistics here. This is not a case where you are actually getting information from the state. It's a moot court question. So therefore, please don't labor yourself on the facts, as if the state has given you information that you have necessary infrastructure. It is an admitted fact that the state is short of facilities and infrastructure. It is not able to provide. Even if 10% of these students are not able to access internet and they are not able to get education, where do you stand? How do you implement this law is the question.
Indeed, Your Lordship, just the fact that the present moot proposition is in parametria with the Indian Constitution was my presumption that the reports and the subsequent advancement will also be in proportion, which is why I've quoted the data and the figures.
No, that is why the question that if you admit that even 10% of the students are not able to access internet and they are deprived of education, tomorrow when they are called upon to write the examination and they say, no, we have not been taught, where do you stand?
Totally understandable your concerns, understand your concern, Your Lordship, which is why I'd like to quote the general defenses that are available to us under the tortious liability. For example, Your Lordship, the act of God comes into the picture in this particular aspect, as the COVID situation is an unforeseen event which could not have been reasonably anticipated by us, and which is why, Your Lordship, it comes under our defense comes under the ambit of same. Similarly, Your Lordship, this particular function that we are carrying out is promoting giving out education is a sovereign function, which is why a suit cannot be held in the court of law for its performance on the same, Your Lordship.
Is it a sovereign function?
It is indeed, Your Lordship, as there is no corporate industrial angle or the profit angle in this particular function, which is why it will be regarded as a sovereign function, Your Lordship.
Well, that may be no profit angle is perfectly all right, but does it by itself become sovereign?
As stated in the sovereign functions, Your Lordship,
it is your dharma to do that, so to say. Anyway, His Lordship wanted to ask you something. Justice Kumar was about to ask you something.
No, what they are trying to show is this ordinance is one thing. That is the Act of 2009. Now, have you
taken steps
to give effect to the 2009 Act? They say this has come in between. Even without this, you have not done your job, is what they are saying.
Your Lordship,
right? It's a fundamental right. There is no dispute. And even after 12 years, 13 years, you have not discharged your liability.
Your Lordship, the petitioners do not. And indeed, Your Lordship, but the petitioners do not.
This COVID is an excuse for you. Think for it that there is no COVID. Have you done your job?
Your Lordship, the first and the foremost is the facts are silent on this matter of whether we have done the job of providing education. Secondly, Your Lordship, the petitioners has also not contended any data as to how much, what is the violation of our same on the carrying out the obligations of Right to Education Act 2009.
You could say, you could have said, I have done the whole thing. You have not deployed education to anybody. You are not saying, hey.
Your Lordship,
you could have the Act is implemented. There is not a single child which is deprived of education. That's the end of the matter.
You have the facts with you.
You are not saying it.
Indeed, Your Lordship, but as a court officer, it is my duty to help the court to reach a reasonable decision, which is why I cannot paint unproved facts and wrong facts.
Therefore, we have to proceed with the assumption that there is a section of the public in the country who are deprived of the benefit of this Act.
Yes.
Therefore, their fundamental rights is violated. And this particular ordinance which you have passed, it has also increased the divide. That is sum and substance of that case. Therefore, at least if you can't implement it, pay damages, provide facilities, that's what they are saying. Even though it is not too late, nobody is going to hang you. They are compelling the government to discharge this constitutional obligation, which is also in conformity with their international obligation. You have gone and signed that international covenant. Signing is very easy. You have to implement it. You have brought it into domestic law. Fine. Making law, writing law is all right. We have to implement it. Then only the citizen gets his right.
Indeed, Your Lordship. But as we've already stated, that the COVID is an extraordinary situation, and this present circumstances in our financial capacity do not allow us to.
You are not quoting this COVID as an excuse for not doing it.
I apologize, Your Lordship. I did not get the contention.
No, thank God you are not taking up a contention. I was doing it. This COVID has come in the way. Not your defense.
If the court allows me to continue with the...
Yes,
Your Lordship. Yes. Much obliged, Your Lordship. Therefore, Your Lordship, with all the contention that has been placed currently, the council contends that the tortious liability does not arise as because of the general defenses that have been available, in terms of the sovereign function, the act of God, and also the doctrine of necessity.
Yes.
On these grounds, if the court is convinced with the argument, I'd like to introduce my co-counsel to continue with the rest of the arguments.
Yes.
Much obliged, Your Lordship.
Greetings to the bench. The council seeks...
You said greetings to the bench. Neither in the High Court, nor in the Supreme Court, or in any court, a lawyer starts with that. I am really afraid. Why are you people starting with that?
Yes. I wanted to tell you this at the end.
A new generation of lawyers. Yeah. It is a fundamental right of a lawyer to address a court. You need not seek our permission.
Okay, Lordship.
Before going to the constitutional validity of an enactment, please look into Advocates Act and right to carry on profession, Article 19. Don't surrender your rights to the courts. Yes.
May it please this court. I'm the co-counsel on behalf of the respondent 03S2, and my submissions will include the validity of the 2020 online learning ordinance. If I have this court's permission, I would like to take up the next issue.
Yes.
The next issue is whether the state is liable to provide financial assistance and digital accessories to ensure universality of education. Your Lordship, I would like to contend that it is not liable because of the two reasons: the guidelines under Article 21A and the medical emergency. Your Lordship, currently we are in the midst of a medical emergency. The health sector is dealing with death rates. There is lack of medical supplies, there is lack of oxygen. And then there is also the production of vaccines. These actions are exacerbating our economic resources to a very large extent. We had to import medical resources of about 80 crore from other countries. And even for the vaccines, we are importing mainly the Covishield or any other vaccines we are importing from other countries. And even the production of these vaccines are exacerbating our economic resources. But even under these circumstances, Your Lordship, we are making sure that there is financial stability within the citizens. We have ensured that there is economic balance, there is economic stability in the country, and have hit a balance between all the ailing sectors, and have enrolled the economic packages for the citizens. And we also understand that education is very much required, Your Lordship. And given our financial situation, where in a period our GDP hit a all-time low of 27%, we understand that education is very important, and which is why we are trying to exploit every other resources there is. That is why we're providing education through televisions or radios to ensure even the deprived students are getting education. And under Article 21A, it states that states should provide education through whichever means, emphasizing on the word state may by law determine, says that it is a discretion of the government to provide education through whichever means it deems fit. And further, in the case of Justice for All versus Government of NCT Delhi, it was held that education can be provided through different means and methods until the basic standard of education has been given. And as according to this ruling and the Article 21A, Your Lordship, we are providing education through the digital platforms or under Pragyata guidelines or Swayam Prabha, through televisions, radios, telephonic conversations, and are exploiting every other option through which we can provide and reach students for education. And even if under any circumstances,
again we would like to repeat, it is not how much you have done, but in your argument, if you are conceding that a small part of the children's group is not able to access internet and they are not able to have education, what is your answer? How do you implement this law without providing for rules in the manner how you could implement that? And when you know that you have not provided for the necessary infrastructure, that is what we want to know. It is not, see, if you concede that even a small portion of the population of the children are not able to access education.
I understand your concern, Your Lordship. I understand, but under the ordinance, it is not just through the online mode it has to be provided. It is through the digital mode, which can be through televisions or radios or even the telephonic conversations. And regarding the information and communication technology in our country, we have invested 887 crore rupees.
No. We do not want to know how much you have invested, but if you accept that with all this still a small portion of the children's community is not able to access education, then where do you stand?
Your Lordship, we're not saying that there is no they are not getting education, but we are making sure that if they do not have a smartphone, if they don't have smartphone, they're getting education through another initiative. So if they're through a television or radios, Your Lordship.
Even that, you considering that also?
Yes, Your Lordship. We are making sure through other initiatives, we are ensuring that each and every child is being educated, and hence are not violating our right to educate, their right to education.
No, the fundamental argument is, and it is accepted also, that the entire population of this country doesn't have access. There is a small portion which doesn't have access. So therefore, their contention is that on the admitted facts that a small portion of the children's group is not able to access education, and when you are depriving them the right of education, are they not entitled to say, no, this argument, this ordinance has to be struck down?
I understand, Your Lordship, but given the circumstances, we are tied our hands to put in lockdowns, and under these circumstances, there is no alternative except the online or digital mode of education. And for the small amount of children being excluded, which is where we are taking the defense of necessity or the act of God, where the small amount of students who are being excluded, and these students also, Your Lordship, we are making sure that once the lockdowns have been lifted or relaxed, or the guidelines are relaxed, we're ensuring that these students also get the hybrid form of education because of the lack of devices.
Madam, 1 year has already elapsed after your ordinance, and
yes,
one academic year examination had to take place by this time.
Yes, Your Lordship, I understand your concern, which is why when after the first wave of pandemic, when the lockdowns were lifted, the small amount of students who were excluded from education were brought back to the hybrid system of education, and given the minimum standard of education which was necessary for that class or for that grade. And under these initiatives, we are trying to cover each and every student. And Your Lordship, the given circumstances, if we do not try to exploit these resources, more students will be left out of education. We can't stop. To not violate the right to education completely is why we have brought the ordinance and making sure that even the deprived students get a basic form of education.
I'm a little surprised that the Council for Respondents have not bothered to look into decided cases where this court has said, even 7-judge benches, that a law has to be adjudged by the generality of cases to which it applies, not by the freaks and exceptions that it martyrs. This is a principle when you're looking at the constitutionality of a law.
In other words, what the esteemed senior advocate is trying to say is that if you are able to justify your action on the ground that the good of the majority is what is to be considered, then you will be able to sustain your action.
Yes, Your Lordship, which is why under RTE Act, which gives protection for the government for any action done in good faith, and as the
that's a different thing altogether. Anyway.
Yes,
please. Yeah.
Much obliged, Your Lordship. And given the circumstances, Your Lordship, if we are forced or persuaded to divert our resources to education or any other sector, it will not just cripple our economy, but it will also affect those lives which have been suffering in the hospitals, and in turn will affect their right to health and right to life. And as right to life triumphs over any other right, which is our main priority, is to ensure that there is maximum or enough resources for enough medical resources, which is why we are contending that the state is not liable to provide further financial assistance or digital accessories. If the court is convinced, I would like to take up the next issue.
Yes.
Much obliged, Your Lordship. The third issue is whether the state's policies are in violation of international treaties and agreements. Your Lordship, the state has been signatory to a lot of international treaties and has followed the obligations set forth in it within time, which is why it has a global standard. And Your Lordship, as pandemic is one of an unforeseen situation, under the International Covenant on Political Rights, it is mentioned that under emergency situations, the state can elude from the obligations arising out of it. And because of these restrictions present in the international treaties, it is first of all not in violation of international treaties. And furthermore, Your Lordship, our constitution talks about international treaties in Article 51. Article 51 states that the state shall endeavor. Here, the word endeavor itself shows that it is not, it's not mandatory for the government to follow the international obligations. And as 51 is placed under directive principles of state policy, they are just directive in nature and not enforceable. And furthermore, under 253, it grants power for the Parliament to enact laws in order to. I sense a query, Your Lordship.
No. Please go ahead.
Okay, much obliged. So under 253, it grants power for the Parliament to enact laws in order to honor the obligations arising out of international treaties. And accordingly, the Parliament in 2009 has incorporated all the educational obligations arising out of international treaties into the RTE Act and has fulfilled these obligations. And as in these cases, we are trying to provide education and not violating education, we are not violating these international treaties as well. And furthermore, Your Lordship, these treaties which the petitioners mention do not mention a mode of education. They say education should be there, compulsory education should be there. They do not mention the mode through which education has to be imparted. And as there is no compulsory mode through which education has to be imparted, our initiatives, our ordinance is not in violation of these. And furthermore, Your Lordship, in the case of Gramophone Co. versus Virendra Bahadur Pandey, it was held that international treaties can be enforced in the country unless it is not in violation of domestic law. And as RT is not in violation of domestic law, and we are following the obligations in RTE Act and not violating right to education, we are not in violation of international treaties. And furthermore, in the case of Jolly George Vargas versus Bank of Cochin, it was held by Justice Krishna Iyer that the positive commitment of the state does not make positive commitment of the state parties ignites legislative action at home, but does not make the covenant enforceable part of the country. And thereby, our positive commitment to fulfill the obligations set forth in these obligations does not make a violation on our part enforceable in the court. Which is why, Your Lordship, the policies made in hindsight of the unprecedented challenges posed by the temporary phenomenon of COVID-19 pandemic, the policies are not in violation of international treaties. If the court is convinced with the issue, I would like to move on to the prayer.
Yes.
Much obliged, Your Lordship. Wherefore, in the light of issues raised, authorities cited in arguments advanced, it's humbly and respectfully prayed to this court to be pleased to dismiss the PIL petition filed by the petitioners and to uphold the constitutional validity of the 2020 online learning ordinance and pass any other order the Honorable Court deems fit in the name of justice, equity, and good conscience. Lastly, I'd like to say, Your Lordship, it's been a pleasure and pleasure to. Am I audible, Your Lordship?
Yes.
I'm very sorry for the time file. It's been a pleasure to argue in front of this bench. Thank you.
Yes. Any reply?
Yes, Your Lordship, the council would now like to present the rebuttals.
Yes,
please.
In the present situation, the respondents have totally denied all responsibility simply on the doctrine of necessity arising, which, however, doctrine of necessity does not permit the fundamental right violations and does not have enough precedent in the present scenario where the fundamental right can be violated simply on the doctrine of necessity, and that is the major reliance of the respondents in the present matter. They have also, on a number of instances, relied on the case of Justice for All versus NCT of Delhi. However, they have tried to mislead the court by not pointing out the fact that Justice for All versus NCT of Delhi has been put on stay order by the Supreme Court a few months back, and all the decisions or judgments in that regard have been put on a stay order by the Honorable Supreme Court. They have also referred to international obligations as not being justiciable. And as much as that is true for the Indian Constitution, the Hoodoo Constitution, as mentioned in the proposition, does contain the word obligation, as referred with respect to international obligations, and it is different from the entire wording of the Indian Constitution, which again has not been pointed out by the respondents and have tried to cherry pick instances. They have repeatedly referred to the guidelines that have been put in place by the state. However, those guidelines, as mentioned earlier as well, are simply advisory in nature, and nowhere in their arguments have they tried to justify how their law does not discriminate or is not arbitrary in any sense. They've also the act of God defense taken by the state in this present matter is something which has not been established properly as how the pandemic does come as an act of God, as it has not been held. Previously also the courts, it has been held that the force majeure clause does apply with respect to the pandemic. However, vis majeure is not something as a precedent that has been held by the honorable courts in this matter since the advent of the pandemic. Even though
sorry, what's that?
The respondents have taken the defense of act of God and the vis majeure.
Yes.
However, the cases that happened during the pandemic, the court did recognize the principle of force majeure. However, not the principle of vis majeure or the pandemic coming under the act of God the act of God criteria, which is why that defense is something which does not have any precedent in that regard. They've also talked about the learning through TV and radio, and again, as mentioned, the law simply states that learning should be through internet, and there are only guidelines. The law, in fact, is not something that they justified in their own arguments by making us understand. The emergency argument that they have portrayed, medical emergency, something which is not legally mentioned in the Constitution, and the emergency is something which is not even, as has been also pointed out by the honorable judges, that it has not been established yet and it has not been declared. So the defense of emergency in this particular aspect is not valid. They've also talked about how the obligations, the tortious liability obligations, they have taken certain measures. However, considering that all of these duties arose even before the pandemic and they have not provided any proof with regards to how their duty was something which was fulfilled by them even before the advent of the pandemic, as the act, the CRFC Act was incorporated in 2009. The respondents have repeatedly tried to take the pandemic as a defense and not realizing that Article 21 is supposed to be upheld even during emergency situations and it cannot be suspended in any circumstance. So they have repeatedly tried to take that defense and repeatedly tried to state the one particular judgment which was put on a stay order. Considering all of these factors, the defense by the respondents does not seem to be in accordance with all the issues raised by the petitioners, specifically with regards to the discrimination provision as well as with regards to the tortious liability arising even before the pandemic. And with that aspect, the council submits that the petition, the honorable bench to take this into notice.
Okay.
Much obliged, Lordship.
Thank you.
Thank you.
Greetings, Your Lordships. Now, to answer the rebuttals put forth by the petitioners, we'd like to start off with their address of the usage of doctrine of necessity. What we have done is, Your Lordship, we have justified the same with the statutory backing of the case of Rangarajan versus Jagjeevan Ram, in which the fundamental rights can be used for the justification of doctrine of necessity.
That you are saying, you are not saying anything new.
That's you're only repeating. Yeah, you have said that.
Your Lordship, we are just contending that the rebuttal that they have placed is that the doctrine of necessity cannot be used in the express of fundamental right violation, but it is contrary to the case law that we just quoted and has similarly been.
Anyway, I don't think that's the ratio of that case.
Yes.
Anyway.
Understood, Your Lordship. Second of all, Your Lordship, they quote that the Pragyata guidelines that we have mentioned are just guidelines in nature and are not a law. But according to the R. Bharneshwaran versus State of Tamil Nadu, the court had made mandatory for the government to implement the Pragyata guidelines, and subsequently every single school under the ambit of central government was made to follow the same. Third of all, Your Lordship, we'd like to place our own rebuttals and contentions here. The petitioners have claimed under para 12 of the memorial that the education is not being provided to 75% of the adult population. But according to the iMobile Research Institute, one of the foremost telecom regulatory, has stated over 45% of internet penetration in India as of June 2020, and is still increasing with 60% by the year of 2026. Similarly, Your Lordship, petitioners have contended para 14 mentioning training of teachers has not been achieved. Your Lordship, we have allocated over 256 crores under the National Education Policy, which was released much before the petition of the case, Your Lordship. Similarly, Your Lordship, they do not give an alternative as to what will qualify as an overall holistical development as mentioned in the para 18 of their MOOT proposition during this extraordinary situation. And furthermore, Your Lordship, para 24, the contention placed by the Learned Council that the complete closure of school will result in susceptible to other factors is completely redundant, as this is a temporary phenomenon, and we are adopting hybrid form of education system after following the COVID guidelines. Similarly, Your Lordship, the council contends that the ordinance is affecting the mental health of the children, but do not give any evidence as to how it is affecting the mental health of these children. And lastly, the council contends that we have not incorporated the Pragyata guidelines, but with the case of R. Bharneshwaran and the state of Tamil Nadu, we have made sure that it is mandatory. With that, we conclude our rebuttals, Your Lordship.
Thank you.
Thank you.
Thank you.
Okay, the teams may leave, please.
Thank you, sir.
Thank you, sir.
Respect to Your Lordships, do you require any assistance in filling up the score sheets?
I am trying to send it by email to your address.
Can I tell you now?
Manya, could you please help your